All right, let's call People v. Sayers. So we're here for sentencing on a charge of operating while intoxicated, third offense with a 5-year maximum, advisory guidelines at 0 to 9 months, driving on a suspended license, 93-day maximum misdemeanor. Have you had a chance to review the report and recommendations with your client?
Yes, Your Honor. Can we approach just briefly?
Yeah. All right, anything you want to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, Ms. Sayers comes before the court at 50 years old with 3 prior misdemeanor convictions, the last being 10 years ago. She fully acknowledges the gravity of the situation. She's very remorseful and she's very embarrassed that she comes before the court for her bad choices. As the court's aware, Ms. Sayers has had significant stretches of sobriety throughout her adult life. And she's committed to maintaining that sobriety and using the tools that she has to do so. She's also committed to re-engaging in treatment to address the trauma that she's experienced so that she can begin to put her life back in order again. She's been attending AA meetings again. She's looking forward to re-engaging with her therapist and doing some counseling. She's been doing some community service work with the Forest Township Hall with Dawn Fenstermaker, and she's got 60 hours in to date on that. She's also got a plan to take care of any fines and costs that the court assesses. We're asking the court to follow the parties' sentencing agreement and the recommendation from the Department of Corrections because we believe it adequately punishes the conduct while allowing for a long term of probation oversight to ensure that the same conduct is not repeated. Ms. Sayers has proven that under supervision, she does very well. She demonstrated that with her perfect performance in sobriety court, having graduated with not a single violation. The bond violation in the incident offense was the only bond violation that she had. She had perfect performance since that slip up, and she took measures to ensure that nothing like that would happen again. We've discussed at length the consequences that she could face if she were to violate the terms of this probation. She understands that she'd be exposed to a possible prison sentence, and that would be, just absolutely devastating to her and her family, especially considering that she was previously employed with the Department of Corrections. For those reasons, Your Honor, we ask the court to follow the recommendation in the pre-sentence report as well as the sentencing agreement struck by the parties. Thank you.
All right, thank you. Ms. Sayers, you don't have to say anything today, but you're welcome to. Is there anything you want to tell me?
First of all, I just want to say that I am so sorry. I'm sickened and so embarrassed because of what I've done. I know that I messed up, and I just want to prove that I can do better. My kids, my grandkids deserve that, and I so deserve that. Thank you.
Thank you. Ms. Goodrich, any recommendations from the people?
Thank you, Your Honor. On December 27th of 2025, law enforcement had observed Ms. Sayers speeding at 88 miles per hour in a 55 mile per hour zone. The deputy had to use her lights and then had to use her siren to catch the defendant's attention. The defendant was honest about speeding and not having a driver's license, and was honest that she drank 3 beers and a shot prior to driving. The lab results were 0.162. She's 49 years old. She was 18 at the time of her first arrest. She has no prior felonies and 3 misdemeanors. She has not been to jail or prison, but on probation twice. She's currently unemployed with a high school diploma. Given her OWI history, specifically in 2001, she pled to an impaired and was given fines and costs. In 2003, she pled to an OWI and was given probation. And in 2016, she pled to an OWI second and was given probation. The PSI is recommending 18 months probation with 30 days jail, which is consistent with the plea agreement. This will be her first jail sentence, and there'll be more available if she violates probation. So I asked the court to follow the plea agreement. And then I just wanted to point out the restitution in number 21. It has the right amount and then has zeros after it. I just wanted that changed. Thank you.
Okay, thank you. Ms. Sayers, please stand for the court sentence. Well, these cases are tricky, because you've got this repeat pattern of drunk driving in your life, Ms. Sayers. I don't know what to say about that. In 2001, you had an impaired driving, got no jail, fines and costs. In 2003, you got a drunk driving, got probation. In 2015, you had your third drunk driving, could have been a felony. You got a misdemeanor with sobriety court. So presumably very little or no jail. And now you get your fourth. I mean, the guidelines don't adequately take into account the pattern of drunk driving in your life. So it would not be unusual for me to even exceed these guidelines on a fourth drunk driving offense and look at giving you a year in jail or maybe even prison. The fact that it's been more than 10 years since your last drunk driving would counsel against a prison sentence. But what's striking to me here is now this is the fourth time you've stood in front of a judge for drunk driving. And you're going 88 on M33 at 2 p.m. at twice the legal limit. Doing 88 miles an hour at M33 stone sober is way too fast. And you're twice drunk. Fourth conviction. And I don't know. I just don't know that I can go along with the fourth time you're in front of a court with that kind of risky behavior. That 4 drunk drivings means Larissa Sayers does a grand total of 1 month in jail. I can't do it. It would be my intended sentence to place you on probation for 18 months, subject to the terms and conditions listed in the pre-sentence report at pages 2 and 3. It would include $225 in an OWI reimbursement, $118 in state cost, $130 in the crime victims assessment, $350 in court costs, $500 fine, and $60 DNA testing fee. And it would be my intention to order that you serve 6 months in the Sheboygan County Jail with credit for 2 days served on the OWI third, which is a true fourth. 93 days jail on the DWLS with credit for 2 days. The probationary order would be on the felony only. Order that you can participate in the CBT or the trustee program if the jail determines you eligible. That would be within the advisory guidelines. I do believe there's reasonable grounds for that incarceration, given that this is your fourth drunk driving conviction and the high risk behaviors to the safety of the public in this case. That does exceed the sentence agreement of 1 month. So that gives you an opportunity right now to have a conversation with Ms. Elliott. You have 2 options. 1, to accept the sentence, or 2, to withdraw the plea and schedule the case for trial. So I'll give you a minute to talk to her. We'll wrap up our morning docket and recall the case of People v. Sayers, 26-7163FH. The court announced a sentence beyond a sentence agreement and gave Ms. Sayers time to consult with her attorney. And Ms. Elliott, what's the decision?
Ms. Sayers is going to accept the sentence of the court.
So the sentence that I announced is the sentence that I will now impose. And Ms. Sayers, you are able to petition for early discharge from probation at the halfway point if you successfully complete the terms. We're going to hand you a piece of paper explaining that. Able to file an appeal if you want with, and if you, we're going to give you a piece of paper about that. If you want a lawyer appointed, you have to ask within 6 months. We're going to ask you to initial 1 copy of the appeal paperwork right now, so we have a record that we gave it to you. The other one is for you to fill out if you want to take an appeal. And then within 24 hours of your release from the jail, I want you contacting your probation agent to get started. Okay. Do you have any questions for me? Okay, good luck to you.
The courtroom hearing begins with Melissa Sayers appearing before the judge for sentencing after pleading guilty to operating while intoxicated, OWI, third offense, and driving while license suspended. From the very start, the judge confirms the charges and sentencing guidelines before asking both attorneys if they have reviewed the pre-sentence report. Melissa's defense attorney immediately asked the court to consider the full picture of her life rather than judging her solely by this latest offense. The attorney explains that Melissa is now 50 years old and has 3 prior misdemeanor convictions, with the last one occurring more than a decade ago. According to the defense, she fully understands the seriousness of her actions, accepts complete responsibility, and is genuinely ashamed that she has once again found herself standing before the court because of alcohol-related decisions. The defense goes on to describe Melissa's long struggle with alcoholism, while also highlighting that her life has not been defined entirely by failure. Her attorney tells the court that she has experienced several lengthy periods of sobriety throughout her adult life, and has repeatedly shown that she is capable of staying sober when she remains committed to treatment. Since her latest arrest, she has already taken important steps toward recovery by attending Alcoholics Anonymous meetings again, reconnected with her therapist, and seeking counseling to deal with the emotional trauma that contributed to her addiction. The lawyer argues that Melissa is not simply making excuses, but is actively trying to rebuild her life before the court even imposes a sentence. To further demonstrate her commitment to change, the defense explains that Melissa has completed 60 hours of community service and has also made plans to pay every fine and court costs imposed by the judge. Her attorney reminds the court that Melissa previously graduated from sobriety court without receiving a single violation, proving that she responds well to supervision and structured treatment. Aside from one bond violation earlier in this case, she has complied with every condition placed upon her. Because of this history, the defense strongly urges the judge to honor the plea agreement negotiated by both sides, which recommends 18 months of probation along with only 30 days in jail. The attorney believes this sentence would appropriately punish Melissa while also giving her the opportunity to continue treatment and prevent future offenses. When the judge invites Melissa to speak for herself, she delivers a brief but emotional statement. Fighting back her emotions, she apologizes directly to court and admits that she is deeply embarrassed by what she has done. She tells the judge that she knows she made terrible decisions and accepts full responsibility for them. Melissa says she wants to prove that she can become a better person and rebuild the trust she has lost. More than anything else, she says that her children and grandchildren deserve to have someone they can be proud of instead of someone who repeatedly disappoints them. Her apology is sincere and heartfelt, showing genuine regret for the danger she created by driving under the influence. The prosecutor then presents the facts of the case in detail. According to prosecution, the incident occurred on December 27, 2025, when law enforcement observed Melissa driving at an extremely dangerous speed of 88 miles per hour in a zone where the speed limit was only 55 miles per hour. Officers initially activated their emergency lights, but when Melissa failed to stop, they were forced to activate the siren before finally getting her attention. Once she was pulled over, Melissa immediately admitted that she had been speeding and also admitted that she did not have a valid driver's license. She further confessed that she had consumed 3 beers and 1 shot of alcohol before getting behind the wheel. Laboratory testing later confirmed that her blood alcohol concentration measured 0.162, which is approximately twice the legal limit. The prosecutor also reviews Melissa's criminal history, explaining that this is not an isolated mistake, but part of a pattern that has continued for decades. Her first drunk driving conviction occurred in 2001, followed by another conviction in 2003. In 2015, she was convicted again and received probation instead of jail. Despite these repeated opportunities, she has now returned to court facing yet another alcohol-related driving offense. However, because Melissa has no prior felony convictions and has cooperated throughout the legal process, the prosecution still asks the judge to follow the negotiated plea agreement of 18 months of probation and 30 days in jail. After carefully listening to both sides, the judge begins delivering his remarks. He explains that drunk driving cases are among the most difficult to sentence because they involve balancing rehabilitation with protecting the public. While he acknowledges Melissa's efforts toward recovery and recognizes that more than 10 years passed between her last conviction and the current offense, he cannot ignore the fact that this is the 4th time she has appeared before a court for drunk driving. The judge says that the sentencing guidelines fail to fully account for the seriousness of such a long pattern of dangerous behavior. He even states that it would not be unreasonable for someone with this history to receive a sentence of 1 year in jail or even prison. The judge becomes particularly concerned by the circumstances surrounding the latest offense. He points out that Melissa was not only intoxicated, but was driving at 88 miles per hour during the afternoon while having a blood alcohol level nearly twice the legal limit. According to the judge, driving at that speed would already be reckless for a sober person, but doing so while intoxicated created an extraordinary risk to every other driver on the road. He explains that innocent families could easily have been killed because of her actions and that the court has a responsibility to protect the public from repeat offenders. In his opinion, a sentence of only 30 days in jail would fail to reflect the seriousness of the crime or provide adequate punishment for someone who had already received multiple chances in the past.